Hello everyone, thank you very much for joining us on our webinar to talk about the new UK immigration system that comes into force from the 1st of January. Hamza and I from the immigration teams at Clarkslegal are going to talk about the changes, in particularly the EU settlement scheme and where we are on that and what checks you need to do. The tiers are all going. Tier 2 means something very different in our COVID lifestyle now. But actually the sponsorship license regime still remains, and it's actually never been so easy to sponsor workers. The right to conduct work checks will also go through because there's various methods in which you can do that now. And we're delighted to be joined by Louise Fryer from PKF, who will talk about the tax and global mobility issue. She's been very busy as colleagues of ours have been stuck in different jurisdictions and the tax implications, even though they would like to stay in the sun. Hamza's going to start off by talking about the changes to the UK immigration system.
Lovely, thank you very much, Monica. So yeah, we'll begin with having a basic understanding of what the UK immigration system is. I'm sure most of you have had some experience with it, but in essence, the UK immigration system requires nationals of specific countries to have immigration permission before they're able to enter the UK. Those who do require a visa, they normally should follow this three-step procedure that we've just put on a diagram. Most of the applicants need to apply for entry clearance from their home countries. They get a visa, they come to the UK border, request leave to enter from an immigration officer. Those who are already in the UK, they either extend their visas or they switch from a different category to remain in the UK. Important, obviously, because those who do require a visa in the right category and do not have it can be subject to enforcement action by the UK Home Office. So obviously, as employers, you can also be subject to enforcement action if you employ someone who does not have a visa to work in the UK. So we look at what the current immigration system is before we see what the new immigration system brings. And when I say current, I mean up until the 31st of December. So the current system has two different distinct categories. So you've got UK nationals and EU citizens, which we've put in a single box. UK citizens have the right to vote in the UK, no conditions whatsoever. EU citizens have enjoyed the Freedom of Movement Directive, which has allowed them to stay in the UK unconditionally for up to 3 months, and thereafter they have to exercise treaty rights, which essentially for those who are employed means working in the UK. There are other ways as well, but we won't go into too much depth with this webinar. Non-EU nationals have been subject to immigration control for several decades. They have to apply, like I said, for prior permission to be able to live in the UK, work in the UK in the appropriate category. There are, however, nationals of specific countries who do not require a visa if they're visiting the UK on a short-term basis. So with the new immigration system, essentially it has already been rolled out on the 1st of December. It does not apply to EU citizens yet, but it gives us a good indication of what will apply to EU citizens. I use the word new entrant EU citizens because these are the ones who are not eligible under the EU settlement scheme, a scheme that allows EU citizens who are already in the UK to stay in the UK permanently. So those who are entering the UK for the first time, do not have prior residence, will have to follow the new immigration system. Overall, the new system, in essence, provides a much greater deal of flexibility, I would say, for the wider class of those who require a visa. It's definitely more complicated than the Freedom of Movement Directive, but for the system or the sponsorship system for non-EU national, it has essentially become simpler, and it is more flexible as well, as we'll go through with you in this webinar. So just to give you a quick background of this, we had the original points-based system that was introduced back in 2008 by the Labour government. And the previous government of Theresa May wanted to move away from the points-based system. And the work was already to move to a non-points-based system was already undertook. But then we had Boris Johnson, who was quite keen on the Australian points-based system. So now what we have is perhaps a hybrid of both of those systems. So we've got now an emphasis on points, as you'll see, where you can trade points if you belong to different categories, but we are moving away from the tier system. So we don't have the word tier in a number of categories. It's still there for some visa options, and obviously it's there for lockdown and how we are in COVID, as Monica mentioned. So there's a brief overview of the different routes that any individual can take if they want to come to the UK. We've got business immigration routes, we've got personal immigration, and students. So the emphasis of today's webinar will be the changes that have taken place on the 1st of December update, and that will apply to EU citizens from the 1st of January. So we'll focus on business visitors. It seems to be a hot topic. We've got employment-based migration, which also has seen substantial changes. So the skilled worker visa and the intra-company transfer routes. With personal immigration, we'll look at the EU settlement scheme. And it is obviously coming to an end of the eligibility of the EU settlement scheme on the 31st of December. So we'll look at obviously how people can still continue to apply under this scheme and what makes someone eligible under the scheme. So starting off with the EU settlement scheme, as I mentioned, the eligibility to be a part of this scheme requires an EU citizen to be resident in the UK before the 31st of December. So if you have been resident in the UK before that date and your continuous residence has not broken, for example, you've not left the UK for more than 6 months, then you can continue to apply for a status under the scheme. And then the deadline for the application itself is longer than the eligibility. So for example, if you're already in the UK or you can establish eligibility before the 31st of December, you can apply all the way up until the 30th of June. We wouldn't obviously recommend waiting until last minute, but that is what the rules are, and therefore you are able to apply for 6 months after the scheme closes. Any individual who applies under the scheme will either get pre-settled status or settled status, and that's determined by the length of residence. So if you've got less than 5 years of continuous residence, the EU citizen will get pre-settled status, which is in essence a 5-year visa, allowing them to complete the 5-year eligibility for settled status, which is a permanent form of status. Employers, however, a note of caution over here, should be cautious against discriminating anyone on the basis of nationality, including EU citizens. Monica will look at discrimination in a bit more detail when we come to it. As of today and all the way up until the 31st of December, and thereafter to July as well, EU citizens can demonstrate a right to work check by showing their EU passports and ID card. However, employers should really be wary of making sure that they conduct the right to work check from the 1st of January, because you will have EU citizens coming in from the 1st of January who in essence will be coming on a visit basis. So they won't have the automatic right to work in the UK, and provided obviously they're not eligible under the EU settlement scheme. We are waiting on further guidance from the government. The right to work guidance has not been updated for this particular issue, but we expect that to be done quite shortly. To give you a quick summary on how this works, we've covered the EU settlement scheme process in a number of different webinars for our clients, in training sessions, in support webinars. But to give you a brief summary for the purposes of this webinar, it's the application process under the EU settlement scheme is divided into 3 different steps. The starting point is the identity, and any applicant can use the EU Exit app, which is available both on iOS and Android phones, and they can use that to scan their passports and go through the process. It's all step by step within the app, so we won't go into too much detail on that. And it tells you whether the identity has been properly verified or not. Those who are not able to use the app for some reason, they can send documents by post as an alternative. The Home Office does send the documents back quite quickly, but it's not as quick as using the app. Once the identity process is complete, the applicant then fills out an online form, very, very basic, but essentially talks about their residence. One of the fields in there is about the national insurance number. It's optional, but those who have worked in the UK and have a national insurance number should absolutely put that in, because what the government does is it does an automated check based on the national insurance records and provides the applicant with possible outcomes. So if they can find data in the national insurance records, they will say that you may be eligible for settled status, pre-settled status, and so on and so forth. It reduces the amount of documents anyone has to provide, and in some cases you don't have to provide any documents if the right outcome is predicted at that stage. Obviously, in some cases, individuals may need to provide additional evidence. Then finally, there's an automated criminality check that's done on various databases in the UK and abroad. Again, automated, so it's important to declare any criminality for applicants. Once all of this is complete, then the applicant would normally receive either a certificate of application first, and then in a few days they'll get a decision which will include their UAN number, but that obviously is just a notification of the decision. The applicant, as Monica will go through with you, will have to conduct, or if they're going to be working in the UK, they'll have to go through right to work process, which is done through a completely different mechanism. Right, so business visits as of the 1st of January, EU citizens will be allowed to enter the UK on business visits without requiring a prior visa. The UK visa system currently does divide migrants into two further categories. These are visa nationals, so those who require a visa even before they want to come to the UK. So for example, you've got nationals for certain countries, they want to come to the UK for a short visit. They need to go to their local centers for visa, apply online, submit their biometrics, get a visa on their passport before they can travel. But we've had a category for non-visa nationals, and these individuals or the nationals of these countries do not require a visa for visit purposes. I've listed the ones that the nationalities who can actually also use the e-gate system. So nationals of Australia, Canada, New Zealand, Singapore, South Korea, and the USA can currently use e-gates, and we expect EU citizens and citizens of the EEA should also be able to use the same system, the same mechanism to enter the UK for short-term visits. Important also because EEA citizens have been able to use e-gates currently and obviously for some time, but the status that they now automatically obtain when entering the UK on a visit basis is quite different. So they're not allowed to work at all in the UK. And that's where we move to conditions. So even though they don't get a stamp on their passport, they are restricted in terms of what they can do in the UK. So the starting point obviously is they cannot stay in the UK for longer than 6 months for any single visit or in a 12-month rolling period. So they can't come back and forth if that period exceeds a 6-month limit in a number of cases. If they're coming in for a business visit, then the visit should normally be linked with that person's employment overseas. So even though they can use the e-gates, sometimes they can be asked to see an immigration officer who may actually be able to question them about their reason for visit, and that is why obviously all of this is important. If someone's coming in for an intra-corporate activity, for example, they've got another company in the EU, they can continue to do so, but again, they cannot come and replace or fill a specific role in the UK. And for that, obviously, we've got other work visa categories. So business visits should only be used for the purposes of visiting rather than working in the UK, living on a long-term basis or studying on a long-term basis as well. Breaching these conditions can lead to denial of entry to the UK and obviously have repercussions for anyone who employs anyone who's on a business visit visa or on a business visit visa basis if the person's a non-visa national. So from the 1st of January, if you want someone from the EU and you want to employ them, you could do the following 4 steps. The first thing is to check if the individual has or is eligible under the EU settlement scheme. If they've already got the status, good, you need to do the right to work check. If they don't have the status, they may still be eligible based on prior residence. So we had an example where someone used to live in the UK but recently moved out to Europe, and now they're going to be employed by another UK company, but they already have pre-settled status. And pre-settled status, as we've talked about in our previous webinars, lasts for at least 2 years. So you have to be outside the UK for 2 consecutive years. So that person is actually able to use that pre-settled status and come back to the UK and work for this company without applying for any other form of status. If that person is not eligible, then you may want to apply for a sponsor license. The process is quite easy if you've got the relevant documents. But however, obviously, if you are sponsoring someone, you should provide them with a job offer at a minimum salary level and a minimum skill level. I'll go through how that's changed under the new immigration system. If, like I said, you've already got a sponsor license, you may be able to rely on updated rules, and we'll go through that as well in just due course. You still should adhere with your sponsorship duties. That's always been there. So making sure that you comply with right to work legislation in terms of reporting and so on and so forth. So how do you apply for a sponsor license? The first thing is to check whether you have the right relevant subcategory. So for work visas, which is the emphasis of this webinar, you've got two categories. You've got the skilled worker subcategory, and like I said, I'll explain what that means for those who don't already know. You also got the intra-company transfer visa as well. So once you've identified what the right subcategory is, you choose that, then you complete the online form, and make sure you've got the third step ready before you submit the online form, which is making sure you've got the right documents. And that would depend on the type of organization you are. So it usually differs between different organizations as to what documents you're able to provide. Once you've submitted the online form, you will then email across those supporting documents, and along with that, a clear explanation of why you need this license. And like I said, obviously the emphasis is to make sure that once you've got the license, you do actually ensure ongoing compliance, that you're making sure that you are reporting to the Home Office if the individual leaves your employment. There are a number of different ones, and obviously that is a topic for another detailed webinar, but make sure that that is all done. As a part of the new immigration system that was rolled out on the 1st of December and applies to EU nationals from the 1st of January, the Home Office has introduced a faster priority service. So you can now pay the Home Office an additional £500 and they can give you a decision on your sponsor license application in 10 working days. So obviously it is good for companies who want to employ someone fairly quickly in the given climate. So the first category that we'll focus on under the work visa categories is the skilled worker visa. In essence, it replaces what we've all known to be the Tier 2 general visa. And any migrants who are entering this particular route from the 1st of December will now be given a skilled worker visa rather than the Tier 2 general visa. So that's what will appear on their biometric residence permits. Those who are already on a Tier 2 general visa and they're looking to make an extension application, they will also move to this category. But it doesn't really affect them negatively because they will be able to use any time that they've got on the previous Tier 2 general visa to apply for indefinite leave to remain. So if they've got 3 years on a Tier 2 general and now they extend and then get 2 years in the skilled worker visa, they should still be able to, as before, use those 5 years in those two different visa categories to apply for indefinite leave to remain. So it doesn't really prejudice anyone on the Tier 2 general visa as it stands today. So the key changes from the Tier 2 route, apart from the name change, is that there has been a reduction of the skills threshold. So it used to be at graduate level before, so fairly high level jobs, and that term, the term for that was RQF level 6. Now that's been reduced to A levels equivalent, so RQF level 3. So you can pretty much sponsor anyone at that level, and obviously that really opens up the pool of employees that you can sponsor. The salary threshold has also been lowered. It used to be a minimum of 30,000 or higher, because the salary threshold depends on the general salary threshold. But if the immigration rules specify a higher salary for that particular job role, then you have to pay that higher amount. So to give you an example, if the relevant standard occupation code said that the salary for a particular role previously was 32,000, you still had to pay them 30,000 rather than 30,000. Previously, if the role was, for example, said the immigration rule said pay 28,000, you still had to pay them at least 30,000. So it is either the general salary threshold or the appropriate salary, whichever is higher. So that's also being lowered to 25,600, and this significantly affects individuals who previously had the immigration rule salary threshold below 30,000, but employers still had to pay them 30. So for those, obviously, employers can now go away with paying them at the relevant market rate rather than paying them 30,000. Applicants can still be paid less. Obviously, we don't advocate for paying anything less than the market rate, but you can actually trade points if the occupation that you're sponsoring for is within the shortage occupation role, and there's a list of shortage occupation roles, a lot of them being in the tech industry, there's some in the architect industry, and so on and so forth. If it's there, you can actually pay less than that 25,600 amount. If obviously the role falls within shortage occupation role, it's within health or education, or the person holds a PhD and which is relevant to the role that you're offering them. And finally, if the person is a new entrant to the labor market, and that usually means they're under 26 or moving from a student visa route. So again, like I said, it is quite something in terms of salary thresholds, the reduction that we've seen in the skilled worker route. We've also got a major headline change is the resident labour market test. Previously, you had to put in job adverts on 2 different websites for 28 days. That's all gone now. You've also got the suspension of the yearly quota for individuals that you sponsored from outside the UK. It was around 20,000, and you had to go through this monthly rotational system, apply to the Home Office before the 5th and get a decision by the 11th of that month. That's all gone, and you can now apply for a defined cause. It used to be called restricted certificate of sponsorship, but now you can apply for what is now called a defined cause at any point in time. You can also importantly switch into any applicant can switch into the tier 2 category if they are on any other visa route except for a short-term route. It was quite limited before because individuals who were on, for example, dependent visa routes such as tier 2 dependent had to go to their home country, apply for a visa, then come back. They are now allowed to switch into the tier 2 general visa. They can also do that if they're currently on a tier 2 ICT visa. They can switch on to the skilled worker visa, which allows them to settle in the UK. We also had this rule of cooling off period where someone who was on a tier 2 general visa left the UK, they were not able to come back for at least 12 months unless they were on a high salary threshold. That's also been removed. So now they can come back straight after, provided obviously the individual meets the relevant rules for that particular job. The minimum salary threshold in certain categories, we saw that you had to pay the individual at least 36,200 for this year, and it used to increase every year. They've removed that minimum salary threshold for settlement. So when an individual reached their 5 years, the Home Office previously required the individual to be paid a minimum salary amount. And for certain roles within the healthcare industry, the education industry, it meant that sponsors had to suddenly up the pay for the individual to be able to stay in the UK. Because also they were only allowed to stay in the UK on the tier 2 route for a maximum period of 6 years. That's also been removed anyway. So overall, like I mentioned, it's quite flexible and removes the previous rigidities that we saw in the tier 2 general route. So moving on to the intra-company transfer visa, again replaces the tier 2 ICT visa and is used by companies who have linked entities all across the world, and they send employees for different projects, usually on a limited basis. The main changes that we've seen to this route are quite similar to the skilled worker route, but again, we've got the removal of the cooling off period. It is quite beneficial because obviously it means that you're now able to employ an EU citizen from the EU for a limited period of time. There is again an addition of the rolling period for maximum stay. It used to be 5 years for standard salary and 9 years if you paid them the higher amount, which was previously 120,000 if you wanted the individual to stay for up to 9 years. That's also been reduced to 73,900. So in essence, you can now sponsor someone on £74,000 and you can have them go back and forth from your associated company for up to 9 years in a 10-year rolling period. There are, again, flexible switching provisions. If you have someone already in the UK and you want to move them to the ICT route, you can do so. You still have to follow the rules for the ICT visa. For example, you still have to have them employed for at least 12 months if they're on the long-term route, or at least 3 months if they're on the graduate trainee route. Now, Monica will go through the impact on employers on all of these different changes that I've spoken about.
Thank you. You'll see that our slides are really detailed because we've condensed hundreds of pages of guidance note, and it's more like an aide memoir for you to come back to, but we may not deal with all of the points on each of the slides. And I also will want to leave about 15 minutes so that we can deal with any questions, so please do put them on the board. So as you can see from what Hamza's is saying, that there's a significant impact on employers in a positive way. Regardless of the rhetoric of the current government, they've actually made it very easy to sponsor workers. If you want to employ somebody who's an EU worker that hasn't been in the UK before, it's the sponsorship license that allows you to do that, and at relatively low rates. It's clearly less bureaucratic. The resident labour market test was a pain. just for the record keeping. But that doesn't really negate from the fact that employers should be doing recruitment wide searches. It protects you against discrimination claims. I'm really grateful to be talking today about employing people because you know, it's been 9 months of redundancies and the market is there's lots of opportunities within the market and lots of people available. So when you're looking at sponsoring people, this will be part of your bigger recruitment plan and your duties to engage in the communities in which you serve. You'll see that there'll be faster turnaround. So when you make a decision, you would be able to employ somebody much easier. The converse is, and I notice Hamza's been very silent on this, when you sponsor somebody, even though the salary thresholds may be lower, the government has quite a lot of fees that come with any application. So that will be a factor that you need to take into account. Clearly, the pool of available workers is much wider for you at a lower skill level if you need. But the question employers need to ask is if you're really employing somebody at an A-level status, it already might be in the local community for you. But what it does allow is for people to switch in countries, none of this cooling off period. It leads to genuinely a much wider pool, and lots of companies are in group organisations, and lots of companies in the UK have survived because of their global operations and the sponsorship by that mechanism. Can I have the next slide, Hamza? So particularly for intercompany visas, it does allow this when you can travel, and you'll see the news that business visitors don't need to isolate. You might want them to isolate, but they don't need to. It allows people to actually travel globally to do their business, to work in countries, and it's a lot more business friendly, and there's no need for this cool-off period. Can I have the next slide? So right-to-work checks, they still very much exist. It is illegal to employ anyone without doing your right-to-work check. It has both criminal and civil penalties. There have actually been 500 fines issued since March, so the government have clearly been looking at right-to-work. There has been a movement both with employers to have more online right-to-work checking themselves, but actually for that check to be valid, for it now to be more online, and they can be relied on as standalone to establish your defence. There is, I can't remember how many pages of the guidance, but there is guidance, and you need to satisfy yourself whether there is somebody who needs just one check, they belong to Group A, say somebody with a British passport, for example, or whether they have a limited right to work and whether they need to go into their continual checks. The old-fashioned way of doing checks still exists. There's been amendments during the pandemic, so they can send you your documents, and then you do a call like this. They wave their passport in front of you, and you do some standard wording if you needed to do those checks in the meantime. But from 2001, we are moving towards a heavily digitized system, and this is a real process where both the employer and the employee must check. But for employers, this is a two-pronged process, and you need to get to the end. And of course, this is a very good check for those who are on the EU settlement scheme. So many employers will have already had workers get their settled status or pre-settled status. You'll have gone through those conversations where they might not want it for very good reasons, and getting over those humps. Or you might have a group of employees that have not yet done it, and there might be some push on them to get that done because the deadline is fast approaching. You might have some employees that are not going to do it because they're going to lobby you to carry on working from the jurisdiction that they want to work for, and that might create issues. Certainly Louise will talk about tax in that regard. Or they might say to you, well, you know, I'm a good worker, I didn't do that, you can sponsor me. And it's whether you want to sponsor an individual where they are putting additional costs to you and perhaps not entered in this open dialogue about their status and what they want in that status. Moving on to the next slide, Hamza. They cannot do a single bit of work, nothing. I don't even say training before you do the right to work checks. And what we have is the current online system, which supports anyone with a biometric resident permit and the EU status. And you'll see that group will be widening, but for those two categories, it's a very good check. You can, of course, carry on doing the manual checks or via this kind of mechanism. But if you're going to move on to doing the online check, it's a process, next slide, Hamza, where the first step is that you need to get consent of the employee to do the check online. That's for data protection purposes. They're actually not really giving that much detail away. So if you're getting resistance there, you need to explore why that resistance is there. They provide they share a code with you, and you enter that code into the portal there. You check the online record, and then you need to obtain a clear copy of the response provided, and you'll see all of the mandatory stages set out in that slide for you. Moving on to the next slide. Remember that even though this is an online portal and you'll see part of the employee side to that, you need to get to the end, you need the employers to do the employer's check of that. And you need to keep that as a record. That will be your record for Home Office and audit purpose. What you see is a dichotomy in the cases between immigration cases where, when they're doing right to work checks, they will often make comments that an employer could do more, even when they've done a standard check, because, and these are cases where there's some illegality, of course. And then you have employment cases where an employee has been with you for some time, say an EU worker. They find it, employment judges are reluctant to dismiss people with generally good records. And what you find is that the middle ground is, as an employer, is that you enter in very clearly now from this date to July that dialogue with how to do searches, why they're important, what the consequences if they don't, you know, that you don't want to lose that employee, but they need to fulfill that, and, you know, that they're not to make any assumptions about the options, that this is a mandatory test. And I think if there was better processes in place, that would defeat any employment tribunal's judge process on fairness about that. Complying with data protection laws, technically you should destroy the right to work records 2 years after the end of employment. I actually take a much broader brush approach and say you can retain for 6 years. Most employers do have at least a 6-year retention period, because A, that's accord with tax purposes, and B, it's relevant for employment claims, particularly as the claims are being stretched out because of resources, and clearly you just need to have consent, and that's generally built into offer letters before, but you may need to modify that if you know you've got somebody who you're going to be doing the online check for. You might want to just amend that in your offer letter. Next slide. There are lots of other changes which I'm not going to talk about, but I want to highlight so that you can come back or go and look at them. There's generally a guidance on each one of them. English language is still required unless you pay somebody a truckload of money, and then suddenly they don't need to speak English language. The English language test itself has changed though, and it's relatively easy. The changes to the maintenance requirement, there's concessions with COVID, which I think will continue all the way through till summer. There is the global talent visa route that still remains, where somebody's a leader of their field, and clearly there are service providers changes for specific countries like Switzerland and the Hong Kong visa. And my next slide gives details of the two categories of the Hong Kong visas, but that is generally a very separate category, but it is relevant to those clients which have Hong Kong operations firstly, or where you get an applicant applying for a job and seeking to rely on this visa and maybe self-funding that visa. I'm now going to pass on to Louise, who's going to talk about the global tax and social security issues with some of these changes that we've been talking about.
Thanks very much, Hamza and Monica. It's a pleasure to join you this morning. I think it's becoming increasingly clear that global movement of employees can be a complex area, and going forward, the changes to immigration will very much affect how organisations structure their people moves and steps that they need to take to do so. Hamza and Monica have gone through a lot this morning, and obviously that's new, but it will become the norm. There's been much general debate around trade agreements and movements of goods, but not so much around people. As you've heard, visa requirements are changing, and an intra-company transfer visa will help speed things up. But when you're thinking about or considering the appropriate visa for business purposes, the tax and social security implications should also be reviewed and the tax planning considered. Whilst immigration and tax go hand in hand, the authorities aren't perhaps as joined up as they might be, and their legislation does not necessarily meet. So you need to think about them separately. As Monica has said, well, employers will have access to a wider pool of workers as the visa qualifications are relaxed. And this is very much an opportunity for companies to offer assignments to the UK as part of career development for non-graduates and to grow talent and incentivise employees. So lots more people to think about. As a result of COVID-19, you may already be dealing with consequences of people being stuck in the wrong place, or perhaps working from home in one country whilst they should be working in another country. Brexit adds a further level of complication to this scenario. We've been advising a lot, as Monica had said, on people that are suddenly affected by international tax rules. So this morning, I will look at tax, social security and healthcare, and what legislative changes we are expecting to see as a result of Brexit. Again, these can be complex areas and where people are working in more than one country or where an organisation has a globally mobile population. Next slide, please. Thank you. As yet, we have no deal with the EU for exiting, but HMRC have separately negotiated 3 withdrawal agreements. One with the EU, one with Switzerland, and another one covering EEA and EFTA countries. So these were effective from the 1st of January 21, and the effect is that they create 2 cohorts of individuals. Individuals will fall into one of 2 categories: either they're covered by the agreements or they're not. And broadly, if a person is in a cross-border situation at the end of the transition period, so as at 31st of December 2020, then they are most likely to be covered under one of those 3 agreements, provided they remain in the same country and they're performing the same role. So there is no disruption to what they're doing. It's to keep things as smooth as possible. Next slide, please. First of all, we'll look at tax, because tax is likely to be less affected than social security requirements. Tax treaties are expected to remain the same because they're based on OECD rules and not EU rules. Having said that, that is the international side. Domestic laws may change, and one example of this is the UK have recently enacted regulations to ensure individuals will continue to receive personal allowances if they are UK non-residents or if they are EU citizens and they're working in the UK. Without that enactment, then those people would have lost those personal allowances. So that's one domestic change. But as I say, international tax treaties which apply over and above domestic will remain the same. Something that we see a lot of, again, is short-term business visitors. Now, Hamza and Monica talked about the short-term business visa and the requirements for that and the kind of work you can do in the UK under that kind of visa. You probably won't be surprised to hear that short-term business visitors for tax is very different. It is previously been with treaty countries, and that will remain the same where there's a tax treaty. But the kind of thing you can undertake, duties have to be incidental. You can't come to the UK and perform your overseas role, but do it situated in the UK. And there's a 183-day limit on being here, and various other rules as well. But it's just important to know that because they've got the same title, they don't have the same requirements. So we talked about tax and tax treaties, not wanting to miss out the non-tax treaty countries, not really affected by Brexit, but it's important to recognise that if a group entity receives business visitors from a resident of a non-treaty country, such as Bermuda, then there are steps that as a company you need to take. Next slide, please. Now we'll look at social security. Many employees who go to another country for a fixed period of time will have a certificate A1 keeping them in their home social security scheme. These people are often referred to as posted workers, and for employees who travel internationally as part of their role, a multi-state certificate is available, again keeping them in their home country scheme. Now, the government have issued guidance around social security for both outbound and inbounds. And first of all, we'll look at the outbound rules. So if you've got any employees that have started work before the 1st of January 2021 that have come from the EU, the EEA or Switzerland, then current rules continue. There won't be a change, and this will remain in place whether there is a future relationship agreement between the UK and the EU on social security coordination, and that is the provisions for that are contained within the withdrawal agreement. Client certificates will have an end date. They're usually issued for 2 years but can be extended. And UK social security should be paid until the certificate expires. Employees and individuals should continue to apply to HMRC for their A1s as normal, so no change at the moment. Still apply for the certificates, they're still the same application forms, everything as normal. However, HMRC will be issuing further guidance as negotiations progress. This is not going to remain the same forever. It is just something that essentially they haven't sorted it out in time, so things will carry on, but they will change, so we need to keep an eye out for what happens. Okay, next slide, please. For those coming into the UK, again, things pretty much as normal. UK national insurance need not be paid for the period stated on the certificate. They continue to pay into their home country scheme, and so long as they don't change their job or their role or their country, everything stays as normal. For employees from the EU starting work in the UK after the 31st of December, if they don't have a certificate already and they're working in 2 or more of any of the UK, EU or EEA countries or Switzerland, then they will need to make an application to the social security institution in the country where they normally reside. Now, the actual process hasn't changed. That is what people do now. But what might change is how their home country views the payment of social security. There's concern at the moment that social security will be payable in 2 countries at once, which goes against the spirit of any previous agreements. And it's that the UK and the EU are working on at the moment. So again, one to watch. Next slide, please. As part of the A1 Certificate of Coverage scheme, at present it's possible to obtain a certificate S1 to cover healthcare needs across the UK. Now, after the 31st of December, across the EU, after the 31st of December, this won't be the case for everyone, and companies really need to think about the lack of available healthcare via an S1. and look at whether they need to provide access to a healthcare scheme as part of an employee's reward package. Now, you may still be able to get an S1 certificate if you receive certain benefits, such as UK state pension. This normally applies to expats that are perhaps retired abroad. If you're employed by a UK body or firm, so if you're a posted worker or a frontier worker who lives in one country and works in another, then you still may be able to get that S1. Or if you're a dependent of someone who already has the certificate, you can still apply for the certificate until the 31st of December. But I would stress that it is not guaranteed that you will, or your employees will, receive that kind of health cover. So if you live in an EU country and there is no deal, then your S1 certificate may no longer be valid. But if you live in Norway, Iceland, Liechtenstein or Switzerland, then you will still have your S1 and it will be valid and you will be covered for health cover. So just something that often gets overlooked until you're in a position when you need the healthcare, but certainly something that you need to think about now. Next slide, please. On this slide, I've left a couple of links. One is guidance for UK nationals living abroad, and the second is the healthcare advice by country. It's going to become much more of an individual country rule situation than having a blanket across the EU. So both those links will help you when it comes to, if you're thinking of sending employees abroad, or if they want to look, or if they want to come to the UK, then our most up-to-date guidance is at those links. So in summary, I think with the changes around immigration, now is an absolutely ideal time to review policies and people plans for the future. So thank you very much, and I will hand you back to Monica.
Okay, so they've tasked me to deal with your questions, to be the question master, but I'm the most technological inept person, so I have to juggle between emails and answering your questions. So the first question is, we've previously had to request the number of causes on our license each year. So this is where your guesstimate of how much you need, and we would say, go higher, go higher. Now, clearly, the question is, do they still need to do that annual check? We know that there are no cause monthly limits, as were previously. You know, that panic when you had to put it in before the 5th for it to be heard, and that delay, that no longer exists. But Hamza, employers will still need to give an indication of how many people that they intend to use their certificate of sponsorship for?
Yeah, so the short answer is yes. And as previously as well, if you do not put in the right amount for your yearly allocation, and this is for the undefined or the unrestricted cause as it was known previously, to employ people who are already in the UK, you could, on a yearly basis, around April, request an allocation that would cover you for the year. The question basically relates to, do you still have to do it? So yes, you have to do it, but as before, you can still ask for an in-country increase in that allocation if you don't get that right limit. So yes, you still have to do it.
And they already hold an A-rated license, and they're asking what would be the critical steps for us to be ready for the changes in the new year. I'm going to start and then let Hamza finish this question. You need to make sure your authorising officer knows what they are doing, and that this is just not another name on a long list of their jobs that they have to do. You need to refamiliarise yourselves with the reporting requirements, the 10 things that you have to report and those time limits, because those are the things that damage your licence, and it will be critical now. So we will see more licences being needed as employers will need to employ more from the EU. The third thing is really to make sure that of your current employees, your current direct employees, that you know whether they have to have continuous right to work checks and your program in relation to that. So it's really about being familiar with the EU settled and pre-settled status and what checks you need to do for that. So those would be my 3 essentials. But the reality is that what they're doing is this mishmash of a system, and it is actually beneficial that they're using the sponsorship license as that mechanism. And I know it's difficult. If you've not been on it, it takes forever. And we have this portal where we can talk through and see in real time the pages that you're entering. But generally, once you get used to it, it's relatively easy. And the helpline, there's been a slight delay in the helpline, I've seen, Hamza, but not that much. So it's really about making sure you familiarise yourself with your obligations, and if you've lost people because of restructures, that you have also made those reports on the immigration system. December's always silly season, and it's proving still to be so. I don't know why people seek to terminate in this month, but that is what I've been observing. Hamza, would you add anything else critical to do so that they are ready for sponsorship license?
Yeah, and I was just going to say, absolutely agree. You need to do a health check, but also, as in one other thing, it really depends on your type of organization and how you're structured. But I would maybe add that if you, for example, have lots of EU-linked entities all across the EU, you may want to get them added as linked entities onto your license, because if you're thinking of transferring employees from the EU to your UK organization, then you need to have that ready on your license before you start the visa process. There are obviously, like I said, it really depends on your particular organization as a secondary measure. Obviously, the primary measure is, as Monica said, do the health check, make sure you've done everything right on your license details, maybe just go through it. And the other thing would be maybe more of a technical thing. You would see, and once you start assigning your cause, you will need to add your PAYE details onto SMS. So that's maybe something you just want to add on. It doesn't take very long. It doesn't require permission from the Home Office. You just need to log on to SMS and add those details. Other than that, like I said briefly, that is what you need to do to ensure that the license is ready for the 1st of January.
I now recognise where these questions are coming from, because the third one, I can recognise the client from there. We're an employer who has hourly paid staff on a variable basis to service events. Wait, hey, events are back. I'm delighted. That was so delightful over the weekend. We have a lot of EU and EA workers. Does the new guidelines mean that all workers must be paid a salary of 26k? No. So lots of the workers will have settled or pre-settled status. They are not sponsored. If you sponsor somebody of that category, then you have to guarantee their salary. And what you're looking for, these are clients that have that pool of variable workers that need that resource, and you probably will get that without needing to sponsor anyone. You might need to work on developing the bank or pool a bit more. The fourth question is actually an easy question. It's maybe I should have started it. Of course, a copy of the slides will be available to all those who have attended the seminar, and we'll send those out. I've got to do question 6. So this is a specific question, I think, for an individual who unfortunately has been terminated in the current circumstances and lost their job, and they're asking, what is the situation for a points-based visa? So Hamza, this is somebody who's clearly been working in the UK under a Tier 2 visa or an ICT, and maybe a quick response about it may be that their visa will be curtailed. They'll be under some exemptions, and what are their options for that?
As in, perhaps this is quite specific to your circumstances, but like Monica said, it would your visa, if it's a Tier 2 visa, as it was called previously, is likely to be curtailed. But you may want to look at your options as to what other routes you can apply for. And that would depend completely to your circumstances as to what options are available to you. You could apply for under the points-based system for the skilled worker visa, provided you can get a job offer from a licensed sponsor.
Okay. Sorry.
Should I cover question 5? I think we missed it.
Sorry. Okay. I'm glad that's why I've got Hamza. Yeah, this is a really good one. Thank you. are you able to briefly talk about the frontier worker visa?
Yes, so obviously frontier workers are all the noise when it comes to individuals who work in, live in one country and work in another, in this case, in the UK. So you've got people from the EU coming regularly back and forth. So frontier worker status, the government has been very slow to give guidance. But in essence, what we expect is this. We expect a new frontier worker permit to be launched on the 10th of December, so 2 days from today. And anyone who is already a frontier worker before the 1st of December should be able to apply for that permit, and they must do at the same deadline, 30th of June, to be able to continue coming to the UK even after the 1st of December and obviously from July onwards. But if you become a frontier worker after the 1st of January, then you need to apply under the points-based system, as we've just discussed, if obviously you fall into one of the relevant categories.
Another good question, which I think applies for a lot of people, and I don't think this is to do with the title of the status of the individual. The director CEO of our UK company is based in Italy and due to COVID has had to remain in Italy all of this year. He has therefore been out of the country for more than 6 months, affecting his ability to get pre-settled status. Are there any special visa exceptions for directors of UK companies? Actually, I don't think it applies just to directors. There is, Hamza, can you talk about the exceptions that are available, because you know some poor people have been stuck in the sun?
Yeah, so so with COVID, the government has introduced guidance on excessive absences. It's always been there that individuals who are stuck outside the UK for any exceptional reason, they can rely on that to demonstrate that their continuous residence has not been broken. The question may have two different elements on there, as in the person is a director, and as Monica said, it doesn't really matter what your particular role is, as long as you're able to show that you were stuck outside the UK because of COVID, and the government has said that they will accept COVID as a valid reason for exceptional absences. I would still say if they're able to travel to the UK before the 31st, then that's something that they should do straight away. But you can still apply, by the way, under the EU settlement scheme, even if you're outside the UK. If they've been working in the UK for a long period of time, maybe they can just apply from where they are. Would depend on, again, their circumstances as well, but no special visa exceptions for directors, but more to do so with COVID. You've got the exception there. You can use that. If they don't already have pre-settled status, then maybe just get that applied for as soon as possible.
Yeah, good luck. Yeah. Good luck talking to a CEO about coming to a fleeting visit to the UK as we wind up towards Christmas. And Louise, we've had a significant number of clients that have now really put their foot down with workers that have been stuck in different jurisdictions because of the issues that you've discussed and creating liability for them. Has that been your experience as well, that generally there has been windows for people to return and set up safely back in the UK? So
yeah, I mean, it's a real mixture, to be honest. The UK authorities issued one relaxation, but that was in terms of establishing UK tax residence rather than whether or not they were taxable because they were working in the UK. A lot of the European countries have reached agreement that if somebody's stuck in one country but would normally be working in another, then the country they would normally be working in retains the tax right, even though they're working effectively from home in a different country. The UK is not party to that agreement. So it's very much on a case-by-case basis, depends on the country you're in, depends how long you're stuck for. We currently have a client who has an individual stuck in, works in Bermuda normally and got stuck in the UK. Now that's a non-treaty country, so that is causing a lot of issues because the company has payroll obligations, but the individual quite clearly doesn't want to pay tax in the UK because as far as he's concerned, he's a Bermudan worker. It's certainly keeping it very interesting. There is a complete lack of guidance, which I'm not sure we should be surprised. Lots of questions are in with HMRC and lots of pleas to just give us something solid that we can work with. But at the moment, it is just not there.
I think from an employment law perspective, if I just talk about that, employers are entitled to dictate the place of work. And even though this has been a long, an awfully long period, it doesn't yet give them implied rights because it's so special the circumstances, 100 years in the pandemic. But we are seeing more employers being lobbied to say, I'm doing a really good job. It's making hybrid working and the new ways of working just another extra layer to that. I'm going to deal with the final question because we're now moving into non-immigration questions, which I think I can deal with very quickly, and I'll give an answer to that very final last one. With Brexit change, anything in relation to GDPR, as I believe there is an EU regulation which the UK replaced the previous Data Protection Act, and are there considerations that we need to talk about? Generally, broadly for both data protection, although there has been some challenges between the data protection arrangements between the UK and the US. I've got one client listening in that's going to go at that, but it's all good, we'll get there. Generally for employment law and the GDPR, the same principles will apply post-Brexit. So in that, there's been a continuation that the law remains the same. The final question was about engaging a contractor in a limited company who is a EU national, and their limited company will be registered in the EU country. Are they still able to do that? That's moving more into a contractual relationship, and there's not enough details in the question of where the work will be being undertaken and for whom, and there are IR35 considerations, so that needs to be just looked at in a lot more detail about that arrangements, because essentially if you've got one person that's providing you personal service, i.e. they can't send their mum to do that contracting job for you, then you are their main client. That will cause you some difficulty going forward. I don't know if Louise, you've got a tax angle or you wanted to add anything further to that.
No, I think you're absolutely right, and the same applies from the tax angle. Like you say, it brings IR35 into question, something that the revenue are looking at extremely closely, because we know they're bringing in the new laws from April 21. So you need, like you say, you need a lot more detail and a lot more information, but it is something to be wary of.
Perfect. I'm not going to look at my emails because we've run out of time. Thank you very much for attending. I think it's not too early to wish everyone a very Merry Christmas and stay safe and healthy, and all the best for 2021. If there's any questions, you've got our emails, please do ping us. But thank you very much for joining.
Thank you.